Ah, the HOA. If you've ever lived in one, you know the feeling. The rules, the regulations, and that little voice in your head saying, hey, shouldn't we, the people who actually live here, have a say? But what happens when you try to take matters into your own hands? Well, we've got a story for you.
I mean, it's a super common question, right? You and your neighbors want to change. Can you just get together and do it? Can you just call your own meeting, take a vote, and make it happen? We're about to find out by looking at a group of homeowners who tried exactly that. Okay, so our story today centers on a case from Arizona back in 2016. It's David Carr versus the Sunset Plaza Condo Association. And it all kicked off when David Carr and his neighbors got together and said, you know what? We've had enough. It's time to change the rules around here.
All right, so let's start at the beginning. Part 1, the request for a meeting. This whole thing kicked off when the homeowners tried to call a meeting. And, to their credit, they didn't just go rogue right out of the gate. They actually tried to follow the rules. And when you look at the bylaws, the rules for calling a special meeting seem super straightforward. Article V, Section 2 lays it all out. You need 5 or more homeowners, you submit a written application to the board chairman, and then the board schedules it. Easy enough, right? What could go wrong? So that's exactly what they did. In early 2016, 6 of them, so one more than they even needed, got together, wrote up their application, and sent it off. They even picked out a specific date and time, Saturday, February 13th at 11 in the morning. But here's where it gets interesting. In that request letter, they added this one little sentence. It seemed like just a reasonable backup plan at the time, but trust me, this phrase is going to become the absolute legal linchpin of this entire case. So yeah, keep that 30-day window in your back pocket. It's important. Okay, so the request is in, which brings us to part 2, a tale of 2 meetings. The board gets the letter, but their response and how the homeowners reacted to it, well, that's what sets this whole thing on a collision course. So here's what happens. The board comes back and says, nope, February 13th is a no-go. They say they've already got a meeting on the books for February 22nd and tell the homeowners, hey, just add your stuff to that agenda. But the homeowners were not having it. They basically said, thanks but no thanks, and decided their meeting was happening on the 13th with or without the board's approval. And they did it. Come February 13th, 9 homeowners show up. Now, this is a 16-unit association, so 9 people, that's more than enough for a quorum. So as far as they're concerned, this is a totally legit meeting, and they get down to business, voting on a whopping 11 different changes to the community's bylaws and rules. So what does the board do? Well, you can probably guess. They completely rejected the results of this, let's call it, rebel meeting. They refused to adopt a single one of the changes. And that's the final straw. This is what pushes homeowner David Carr to take the next step, filing a formal legal petition. And just like that, this whole dispute is headed for a judge. All right, so now we're in part 3. The judge makes a ruling. The fight has officially left the condo complex and is now in the courtroom. An administrative law judge has to step in and try to untangle this whole mess. Okay, before we get to the actual ruling, there's a quick legal term you need to know, preponderance of the evidence. It sounds fancy, but it's pretty simple. This isn't a criminal trial, so there's no beyond a reasonable doubt stuff. All Mr. Carr had to do was prove that it was more likely than not that the board messed up. It's a lower bar to clear, for sure, but he still has to clear it. So the first big question the judge had to tackle was this. Did the board actually break the rules? Did they illegally deny the homeowners' meeting on the 13th? This was really the heart of Mr. Carr's whole case. And the judge's answer? A flat-out no. But why? Well, remember that one sentence from the homeowner's own letter? The judge pointed right at it. By offering a meeting on February 22nd, just 9 days later, the board had actually met the terms of the homeowner's own backup plan to meet within 30 days. So legally speaking, no foul. The board didn't break the rules. Okay, so the board didn't act illegally. Fine. But what about the meeting the homeowners held anyway? They had a quorum, right? They all voted. Do those votes actually count for anything? This is where things get really important. The judge dug into the governing documents and found this critical difference. And seriously, this is key for understanding any HOA. There are 2 kinds of documents. You've got the bylaws. Think of this as the community's constitution. The judge found that only the Board of Management can amend those. Then you have the rules and regulations, the day-to-day stuff. To change those, the board has to propose it first, and then a majority of homeowners have to approve it in writing. The key takeaway here? Homeowners can't just kickstart either of these changes on their own. So the final ruling on this was crystal clear. Nope. The homeowners just did not have the authority to do what they did. That meeting they held on February 13th and all those votes they took, according to their own community's documents, it had absolutely zero legal weight. And that brings us to our final section, lessons from the bylaws. Because with the ruling in, this case really does have a powerful lesson for any homeowner out there who wants to change things in their community. So the final outcome? Well, David Carr's petition was dismissed. All those changes the homeowners voted on, they were not adopted. Now, what's kind of interesting is that the association actually asked the judge to penalize Mr. Carr. But the judge said no. He basically said Carr didn't file a frivolous case. He just misunderstood the rules. So in the end, the judge just ordered everyone to abide by the documents as they were written. Simple as that.
And this really is the crucial takeaway from this whole thing. It doesn't matter how many of your neighbors are on your side. It doesn't even matter if you have a quorum. Your power as a homeowner, your rights, and the exact steps you have to take to make a change, it's all spelled out in black and white in those governing documents. You absolutely have to know the rules of the game before you can even think about trying to change them.
Which kind of leaves us with one last big question to think about. Is your HOA a democracy or is it a business? We often think of them as these little democracies where everyone gets a say. But a case like this shows they really operate a lot more like a corporation. They're governed by a strict set of bylaws that clearly define who has the power and who doesn't. That difference between changing the bylaws and changing the rules, that's not just semantics. It's a core part of the corporate-like structure. So it's worth asking yourself, which one is your HOA? And maybe more importantly, have you actually read the documents that say what you can and can't do?